Welcome. Today we get to talk about division orders, which are usually something that is signed to supplement the lease. So it's not part of the oil and gas lease, but basically what it does is it authorizes how funds are distributed from an oil and gas well. So it says, for this particular landowner, maybe they have a quarter share of the mineral interest and it's a 1/8 royalty. So they get 1/32 of all the oil and gas from that well. Now, the royalty and working interest owners typically give these to the oil and gas company so that it will sell oil for them that otherwise, under the terms of the lease, they would receive in kind. So as we saw, generally in an oil and gas lease, you're entitled to a share, maybe 1/8 of all the oil produced. And by the literal terms of the oil lease, that would just pile up for you. You'd have a bunch of barrels of oil, or you'd have some storage of oil, and the oil and gas company would just leave 1/8 of that for you. Now, a lot of landowners don't want that. They want the oil company to sell the oil and just give me a share of the money, just like is the case for natural gas, where you just get a share of the money. And so that's often accomplished through a division order that allows the oil and gas company to sell the oil and give the appropriate share of the money to the landowner. So here's an example of what it could look like. You agree to pay at your posted per barrel field price. We'll talk more about that in a little bit, but the oil company will have a posted per barrel price, or if the oil is purchased by a nominee, the price shall be the same received from such nominee. So in other words, if the oil company isn't paying for the oil at that posted price, and it's sold to a purchaser, well, then whatever the oil company got for it, the landowner should receive. Or if you do not agree to pay the posted price, the price shall be an agreed price. So there can also be an agreed price that determines, agreed between those two parties, that determine how much money the landowner receives. All right, so it can be helpful to see some of the complications that arise when the division order has terms that seem to be different from the lease. And the case that we have about that in our book is this Govenda versus Strata Energy case. It's a Texas case from 1986, so a while back now, 35 years. It's on page 434. So this was all based on a 1967 non-participating royalty. What's a non-participating royalty? Okay, remember, that's a royalty that doesn't participate in the lease. It is not created by the lease. It's kind of like a portion of a mineral interest. It is something that a landowner who has all their minerals gives to somebody else, a share of production. Unlike the mineral interest, which says you have a share of the oil and gas in the ground, you have a share of what's ever produced from this property. And the specific terms of this non-participating royalty interest were that the grantors reserved for a period of 15 years an undivided 1/2 non-participating royalty. So it's a 1/2 royalty. So not like an 1/8 royalty or traditional royalty. Keep in mind, this is now 1967, so it's over 50 years ago when a lot of people had 1/8 royalties. This says, no, I want a 1/2 non-participating royalty. Notice that this was created by the landowner when they sold it. So the grantor said, I'm selling you the land, but I'm reserving for myself a 1/2 non-participating royalty. Okay, so wells are drilled in 1979 and 1980 leases from the new landowner, right? Because this is 12, 13 years after the new landowner purchased in 1967. And the new landowner says, okay, here's a lease, one normal 1/8 royalty to the oil and gas company. So the oil and gas company, what does it do? Well, it has to figure out from this oil well, how much do I give to each party? Now, obviously with the landowner, they're giving that 1/8 share. how much do they give to the Govendas under their division order that says what it's doing from that well? Well, they didn't give half of the oil from the well. Instead, they gave 1/16 of the oil from that well. Why is that? Well, we'll talk about that. But why did the oil and gas company make this mistake? We'll talk about it. The Govendas discover this error a few years later, and they say, okay, we were supposed to be receiving 50%, half of this oil that was produced from this well in the first couple of years of this lease. And so they sue Strata Energy and they ask for that 50% share going back for the 2.5 years it's been operating. Court says, yes, the Govendas can recover because it was Strata's mistake. Even though the Govendas signed the division order, even though they took payments under this order for a couple of years, really this is Strata's mistake. And what we'll see in Texas is that in Texas, typically you're required to sign a division order, but that doesn't alter the underlying lease. Okay. So first question, how did the oil and gas company make this mistake? Well, let's notice how unusual this non-participating royalty interest is. This is a 50% royalty. So the normal is 1/8, right? 12.5%. And somebody here who was actually not even on the land anymore, now belongs to somebody else, is reserving a 50% royalty. Okay, why does the 1/8 royalty exist? Well, it's because oil and gas companies typically believe that given the risk they're taking, given all the capital they're investing, it is not going to be worth it to them unless they are going to receive 7/8 or so, the lion's share of the oil and gas from that well. So what would normally happen if you knew as an oil and gas company that when you drilled on some land, 50% of that oil would go to somebody else? You would never take that lease. You wouldn't take that lease unless it was just the most bizarre kind of sure thing, because you can get a lease where you keep 7/8. You don't want one where you're paying 1/8 to the landowner and 50% to somebody who is long gone. That's crazy, right? And in fact, what could the oil and gas company have done under this reservation, right? Notice the specific terms. Grantors reserves for a period of 15 years an undivided 1/2 non-participating royalty. So when did that expire? 1982. Well, the oil and gas company here would have never drilled in 1979 and 80 if it could have just waited till 1982 and been able to keep 7/8 of the oil instead of giving half to the Govendas and 1/8 to the landowner. So this is a very unusual non-participating royalty interest because it's so huge. And the reason you don't see that, of course, all landowners would love more money, is because if you have a non-participating royalty interest that's that huge, there will never be any production on the land because no oil and gas company will touch it. So you don't usually see a number. So when the oil and gas attorneys from the company looked at this non-participating royalty interest, what did they think it said? They thought it said 1/2 of the royalty. So not a 1/2 non-participating royalty, I get half of all production from the well. But I want 1/2 of whatever the landowner royalty is. And that's why the oil and gas company said, oh, well, you just want 1/2 of that 1/8 royalty, so you're getting 1/16. But there's no of in that sentence. It says a 1/2 non-participating royalty, you get the full 50%. We'll look more carefully at how you construct the language of a non-participating royalty interest in future classes, and you'll see how to avoid this mistake. But that's the mistake the oil and gas company made, is it thought it looked like this was a normal non-participating royalty, something like 1/2 of the lease royalty, 1/2 of the normal royalty. But in fact, this just said 1/2 royalty. Okay, the other important question here is that on page 435 and 430, or mostly in 436, you see the court discussing this Middleton case in Texas. So remember I said usual rule is that the division order can't change the lease. Middleton is sort of the one exception to this rule, because what happened in Middleton was that it was a market value lease for gas. We know in Texas, we follow the VELA rule. So market value means what the gas was worth at the time. The company, Exxon in this case, had Middleton sign a division order that said, I'm going to pay you based on the contract price, not on the market value price. So that's kind of like the Terra rule, like what they have in Oklahoma. The lessor complained and said, hey, you can't change the terms. My lease said market value, and you're giving me your proceeds, what you actually receive. And the court basically said, well, that kind of difference, not big enough. If you sign off on the division order, that's enough. Okay, that's, I would say those two cases are theoretically inconsistent, but the basic way you could think about it is maybe some tiny differences between the lease and the division order are going to be okay. You know, you sign off on the division order. This doesn't really necessarily benefit either party. Or at least not systematically, that might be fine. But this kind of big change, like we saw in Govenda, going from a 1/2 royalty to a 1/16 royalty, you can't, even if you sign that division order, that's not going to change your underlying legal rights. So these are the big issues that recur with division orders. First, does a royalty owner have to sign a division order? Okay, so the oil company is going to give you a division order based on its best read of what your lease requires. Do you have to sign it? Well, yes. So in a lot of, not everywhere, but in many states, including Texas, if it's a valid division order that reflects your legal rights, you do have to sign it. Okay. And that can, by the way, be a good preview of what some of the issues are if your oil company has a different interpretation of how much oil you get than you do. Okay, second question. Does that amend the lease? And the answer is generally not, at least in Texas, no, except for with this Middleton exception. So sometimes there can be differences between the division order terms and the lease terms. But in part because we ask lease owners to sign these division orders that help the oil and gas company figure out how to share out the revenue from a single well, that typically, as we see in this Govenda case, will not modify the substantive terms. Although you want to be careful about that because as we see with Middleton, there can be slight differences in how gas is valued under the division order versus under the lease royalty clause. Okay, another question, if you accept payments. So there's two things we could say the landowner did to ratify a division order. One is signing it, and two is accepting payments. What we see from the Govenda case is even if you've done that, if there's a big substantive error in the division order, it's not supposed to change your legal rights, at least in Texas. But you can see in your book that the different ways different states have handled that. All right. Next big question about pricing is the posted price dispute on page 439. This is when the lessee, oil and gas company, buys the lessor, the landowner's oil production. And the question is, okay, does the lessee, the oil and gas company, have to pay a fair price? Because if the lease just says the lessee has to pay the posted price, is that enough standing by itself? Well, short answer is yes. It has to be a fair price. You can see that in the notes. You can think about that. Is there an implied covenant to market? Remember, we talked about that with gas, the requirement to get a good price and to pay and to find somebody timely to purchase that gas. The same thing can exist with oil, usually easier to sell oil. There's also the question of, if you're looking for a market price, where is that market? Do you look at a price at a hub where all those pipelines collect, or do you look at the price just in the field where it's produced?